We are Group 1 and we are covering the Canterbury Earthquake Insurance Tribunal. As the name suggests, the Canterbury Earthquake Insurance Tribunal deals with the Canterbury earthquakes of 2010 and 11, which caused catastrophic damage to the Christchurch region. Many buildings in the city, including homes, offices and public buildings, were severely damaged or destroyed. The insurance situation after the Christchurch earthquakes was really complex, and many homeowners and business owners were left in uncertain situations regarding their insurance coverage. The tribunal was set up in 2019 to facilitate a fair and cost-effective way for homeowners and businesses affected by the earthquakes to engage with their insurance providers in order to resolve these disputes. The tribunal is independent and resolves these disputes through mediations and hearings rather than through the traditional court processes. Prior to the tribunal's creation, the use of the court system to resolve insurance disputes arising from the earthquakes resulted in expensive and lengthy litigation for homeowners, most of whom had already lost their homes to the earthquakes. Furthermore, the power imbalance between large insurance companies and individuals forced many homeowners to enter unfair settlement agreements due to the heavy burden of court costs. I think this quote from D-Trust and AIG NZ Limited nicely sums up some of the issues that cropped up from the litigation process before the tribunal was established in 2019. You can see the judge here is talking about there being widespread dissatisfaction with the litigation going through the High Court. It was expensive, litigants were unevenly matched, with homeowners facing large bills for experts and lawyers. Costs automatically followed the event, so homeowners found themselves being forced to settle because of the risks they ran into conducting expensive and time-consuming litigation. The tribunal aims to address some of these issues by providing a fair, speedy, flexible and cost-effective method of dispute resolution. One of the ways it does this is by making all costs related to mediation, expert evidence and hearings not borne by the litigants personally. Also, the litigants are not required to obtain legal counsel, so they're saving on lawyers' fees and also the time it takes to engage a lawyer and go through the traditional court process. This also means that homeowners can have the benefit of having their case heard without the risk of incurring substantial costs, and therefore they can avoid predatory settlement proposals and have access to justice. In terms of governing rules, the tribunal is governed by the Canterbury Earthquake Insurance Tribunal Act 2019, which gives the tribunal the power to hear and make binding decisions on the extent of payable damages and also the interpretation of particular insurance policies. And then there's also the pretty standard caveat that the tribunal must have regard to the principles of natural justice.
The tribunal is an independent body that is empowered to make binding decisions on disputes related to claims under the Earthquake Commissions Act 1993, as well as the insurance policies of private insurance companies. The Insurance Tribunal has significant and flexible powers conferred by the Act. It can direct parties to attend mediation and adopts an inquisitorial process pursuant to Section 40. As it is inquisitorial in nature, the tribunal can investigate the facts of a case, but it is also subject to the principles of natural justice and is guided by what is fair, as Caitlin mentioned before. The tribunal has the authority to designate specialist advisors, and in certain situations, it may refer questions of law to the High Court. Homeowners hold the power to petition for their case to be moved to the tribunal from the District Court or the High Court. However, insurance lack this ability. A unique aspect of the tribunal's processes is that the cost of mediation, expert reports, legal opinions, and hearings are not met by the parties. The tribunal also includes a fully funded independent mediation service provided by the Ministry of Business, Innovation and Employment. Mediation settlements are confidential, binding and enforceable, and the settlements made outside of the tribunal can also be sealed at the homeowner's request and be enforced by the district court.
Who can apply? People wishing to bring a claim are eligible to apply to the tribunal if they are the homeowner and have an unresolved insurance claim relating to the Canterbury earthquakes of 2010-2011. Damage that occurred after 2011 may be considered if at least some of the damage occurred during the 2010-2011 earthquakes. And they have a claim involving a private insurer, Southern Response and/or the Earthquake Commission. Applications brought to the tribunal are free. It is easy to apply and you are able to do this online or on mail. The claim can be a new claim for first-time settlement, a claim reopened because additional earthquake damage or bad repairs were found, a claim that's gone through other resolution services but remains unresolved, or a claim already filed with the court which one can apply to have transferred to the tribunal. And case manager will be assigned to the case. The application and supporting material will be sent to the respondent, giving them a date for the first case management conference. The respondent must forward any documentation relating to the case to the tribunal and to the claimant as under Section 15 of the Act. If the claim is not accepted, the homeowner will be informed the reasons for this decision and be advised of other options. Homeowners can ask for a review of this decision. The purpose of the case management conference is to meet the parties and their advocates, figure out what is agreed between the parties and what is in dispute, confirm that everyone fully understands the nature of the dispute, decide whether other parties should be added, and to decide on the best way to achieve a speedy, fair, and cost-effective outcome. After the conference, the tribunal consults with the homeowner and insurer and decides whether the claim goes to hearings or mediation. If the claim goes down the hearings pathway, the tribunal will ask the homeowner permission to visit the home that is the subject of the claim. If the claim does not go down the hearings pathway, the tribunal will arrange for mediation through the Ministry of Business, Innovation and Employment.
Site visits take place soon after the first case management conference. A tribunal member will ask to visit the affected property with the homeowner's permission. Hearings are held by a Canterbury Earthquakes Insurance Tribunal member. The purpose of a hearing is to clarify and test the evidence. The substantive hearing of a claim must be held in public, subject to exceptions as under Section 42 of the Act. The judge will decide whether there is an exception after hearing from the parties and having regard to the interests of the parties involved and the public interest. The claimant and their advocate and respondent and their advocate must attend all hearings.
Resolved. The member may ask to clarify any areas of confusion, and the respondent or advocate will have time to ask further questions. The respondent may only give evidence if the evidence has been filed in affidavit form, circulated to the other parties, and is compliant with the tribunal's directions. Expert evidence. The tribunal may arrange for an independent expert report as under Section 25 of the Act, a meeting of the parties' experts to review and discuss reports and create a joint statement on matters they agree or disagree with, advice from technical experts which are sent to all parties, or experts to attend a tribunal hearing. Withdrawal. A claimant may withdraw a claim if both parties agree as under Section 11 of Schedule 2 of the Act. Settlement. Parties may settle at any time up until when the tribunal makes their decision.
Mediation is done by an independent mediation service. If you cannot be settled by mediation, then there will be further case management conferences and the case will go down to the hearings pathway. However, if you can reach a settlement through mediation, then that settlement will be confidential, binding, and enforceable. All tribunal decisions are binding and enforceable.
A tribunal's decision may be appealed by a party to a claim of the decision upon a question of law or fact. Appeals are required to be filed in the High Court, and they also require the leave of the High Court. Both the notice of appeal and the application for leave are required to be filed together. They are required to be filed within 20 working days of the tribunal's decision, or within an additional time frame that is approved by the High Court. The decision made by the tribunal can be affirmed, changed, or overruled by the High Court. Any remedy, award costs, or interest which can be issued by the tribunal can also be issued by the High Court. The High Court rules are applicable to appeals made under Section 54 of the Canterbury Earthquakes Tribunal Act 2019, unless it has otherwise been amended by the Act. A High Court's decision can be appealed to the Court of Appeal, and a Court of Appeal's decision can be appealed to the Supreme Court. However, such appeals must have the leave of the court which it is appealed to, whilst the appeals can only be upon a question of law.
The tribunal has provided many homeowners with an understanding of what they are actually entitled to. For Ellison and Carl Dodds, they were underpaid by Southern Response and took them to the tribunal. The tribunal found in their favor and found that there were actually 2,700 other homeowners in the same situations. Ellison said that it was a simple process to apply, and that their work in bringing a claim has benefited many others, such as Lee Henderson, who was underpaid by $100,000. Henderson now has this money, which although was something she was short for, she said it felt like winning lotto. This highlights the huge difference the tribunal has been able to do in people's lives. Without the tribunal's role, these claims would have dragged on for many more years, costing a lot more money. Justice Minister Andrew Little said it was pleasing to see one of the longest standing claims has been settled within 50 days of the tribunal starting. Another example of a substantive issue is Kitchen and AA Insurance. AA Insurance opposed Lewis and Sharon Kitchen's application to transfer their case from the High Court to the tribunal, arguing that the case was too complex and novel, and that a transfer would cause delay and add cost to the settlement, as the court date was already set for early December. However, Justice David Glendale did not accept this and ordered the case to be transferred to the tribunal. Being a complex case is not a reason to not go to the tribunal, when complexity is likely to be a factor as to why a resolution was not reached years ago. The tribunal also ruled on whether it was appropriate for the defendant to have counsel from Auckland, which shows your broad scope of powers.
This case provides an additional prime example of the significant issues decided in the Canterbury Earthquake Insurance Tribunal. One of the principal matters in question was whether Vero had a contractual obligation to repair the downpipes and spouting as a result of the earthquake damage. It was determined that Vero did in fact have a contractual obligation to repair under the insurance contract they held with the claimant. This remedy was essential to uphold the insurance policy standard to ensure the components functioned correctly by directing water away from the property, therefore preventing any adverse effects of stormwater accumulation. It was subsequently established that an insurer is liable for losses resulting from defective repairs, where it assumes the responsibility to remedy them in the first instance. Therefore, Vero was required to remedy the defective repair in order to meet its contractual obligation. As a result of the defective repair, the claimants incurred a cost of $119,422.74 to construct a retaining wall in order to remedy the defective repair. Accordingly, Vero was ordered to pay the claimants this amount plus interest, in compliance with Section 47(4) of the Canterbury Earthquake Insurance Tribunal Act 2019.
In June 2019, the Canterbury Earthquakes Insurance Tribunal was set up through the Canterbury Earthquakes Tribunal Act 2019. The tribunal allows homeowners impacted as a result of the Canterbury earthquakes in 2010 and 2011 the ability to bring claims against their insurers as well as the Earthquake Commission, without going to court. When the tribunal manages claims, the tribunal is required to consider quickness, cost-effectiveness, fairness, and flexibility. In relation to quickness, Justice Minister Andrew Little stated that the tribunal will be a circuit breaker for those disputes that have dragged on for too long and will provide homeowners with closure and the opportunity to move on with their lives. Regarding cost-effectiveness, applications made to the tribunal are free and the mediation service is entirely funded. Regarding fairness, the principles of natural justice are required to be abided by the tribunal. Lastly, in regard to flexibility, Andrew Little stated that the tribunal would result in being a very human and accommodating process.